All right. Good afternoon, everyone. Thank you so much to those of you here in Geneva for joining us for the panel discussion today, and to those of you online as well, a warm welcome. My name is Anita Ramasastry. I'm a professor at the University of Washington School of Law, and for 2 to 3 decades of my life, I've been working on these issues of corporate complicity in war and international crimes, and the issue of remedy and accountability. So it is my honor and pleasure to be moderating this panel today, and just to be reflecting upon the fact that when I began writing, I was focusing on issues relating to the Second World War and Japanese and German companies. And yet we are in 2024, and we're really dealing with both historical issues of still trying to seek remedy for those who are harmed in relation to business human rights abuses in conflict, but also the fact that we're in a place where the violent conflict continues to escalate, and business, of course, is engaged in conflict-affected areas. So today we're really trying to figure out what is the relationship between the issue of the right to remedy, the UN guiding principles on business and human rights, and the issue of businesses' involvement in international crimes. It's a very complicated issue, but one that we need to actually find a way forward for many reasons. So I'm going to begin. Of course, we have 4 panelists who can speak to different aspects of this, but to begin with actually speaking about what is the impact to rights holders and to people, we have with us the Reverend James Ninru Dong, the Right Reverend, who is from the Presbyterian Church of South Sudan. Reverend James, you've traveled a long way to come to be here with us today, and so we'll have you, I think, begin and set the stage in terms of speaking about the Lundin case and the search for remedy. So thank you.
Well, good afternoon. As I was introduced, I'm Reverend James Ninru Dong, pastor of Presbyterian Church of South Sudan, and also a member of the Victim Voice. If I could just, I don't know how many minutes do I have, but if I could just go to a little background about Lundin. The case in question started when what we call the comprehensive peace agreement was signed between the rebels fighting for the independence of South Sudan and the Sudan government. That was around 1997. Then, coincidentally, or by design, it was the same year that Lundin came and signed the contract for concession in Block 5A. Block 5A is in Unity State, Western Upper Nile, and inhabitants of those areas are Nuer. When Sudan signed that agreement with Lundin, by then the area was contested between the Sudan government and the rebel known as Sudan's People Liberation Movement Army. So the area was not secure. As a result, an investor would like to have a secure area to protect their interests. So they went into another agreement with Sudan to provide that security. And as a result, provision of security entails displacing people and taking the land by force. And as a result, we suffered so many losses. 200,000 people were displaced in their areas. 12,000 people were killed directly or related. 40,000 people became their homestead were destroyed. 500,000 people, head of cattle, goods, animals that constitute livelihood for the people in Unity State were looted or killed through cross-firing, or looted to give incentive to the militias. The community suffered also indirect losses in employment, education, good life, which subjected them to psychological and physical suffering. In 2006, after we got the independence of South Sudan, we had a civil society meeting in Juba, and this is where we place a request to the ECOS, which is European Coalition on Oil in Sudan, that they help us investigate the matters of displacement in Unity State, Western Upper Nile. And this is when the unpaid debt was produced, which is the basis for the complaints that we raised. And the unpaid debt was mainly asking for compensation, and we detail everything, and this is online. The main ask of the community was compensation because we were displaced from our areas, and our consent was not taken when the oil company signed the contract with Lundin. I would like to talk also about the compensation concept in Africa and also in Nuer community. Compensation enter in every business that a relationship that the community in Nuer do. For example, marriages, marriage settlement, feud settlement, anything that was damaged because we don't have that currency is around compensation, either in kind or in cash. So the Nuer would like, for example, I give you example of marriage. If two families have to enter into a marriage, the family of the man would come and sit, and the family of the girl would sit, and then the first question before prayers, before greeting, before anything, the family of the man would ask, is there any grudges against us that we need to settle before we move forward? And if it is confirmation, yes, then somebody will come up and state what was the grudges. And if people agree that was correct and it has been done, then that would be settled first. And the settlement would be in kind, either by bull or giving cows or something symbolic that will entail two things, that the offended party agreed that they have committed a mistake and therefore they are sacrificing something to say sorry. Once that is done, now prayer will come, greeter will come, and then a settlement would be entered into. It's the same when a person is killed, blood compensation do so. And every aspect of our life, even if your crop has been damaged by a cattle from the neighbors, this is how you settle it. So when the Lead Victim Boys came up with the issue of compensation, is from that background, is from that cultural background, that we need also, Lundin need to take 3 steps. First, they need to acknowledge that they have done harm into the people because they have entered our land without our permission and entered it also forcefully, using Sudan government and the militia to displace people for them to extract oil. That was not agreement that, as we say. We could see also from our constitution, the compensation is provided for in the CPA, the agreement I quoted earlier. The compensation is also provided for in the Petroleum Act 2012. It's also provided for under Chapter 5 in the recent agreement of the ARCs, which is 2018. It's provided for under transitional justice, where under the section of compensation. So it's a right call. When Lundin knew that, and the case was open and was on, Lundin made another tactical move, transferring their assets into a different company in Norway, and 98% of their assets were transferred, leaving them with only 2%, which would not be able now to cover the losses they made. And even if we get the right for compensation, that money would not be enough. So that is also a tactical move, and we are trying also to chase them and see how we could do that. The CPA, as I said, acknowledges that people of Unity State and other producing oil areas has suffered, and therefore, within the Agreement of Petroleum Act, 3% of the oil proceeds has been allocated for damages, and that is from the background of compensation. Now, if I could come to an end, we are happy that finally the case of Lundin is on, and we are happy also to see the UN Principle on Business is also addressing such issues. And I was happy to sit with Ian Lundin and Alexander Schneider in the same room, courtroom in Stockholm. That was seemed to be very impossible some few years ago, but now it's possible, which means somehow the law is working. And I hope the UN body would push further that those who are supposed not to sit in the table are to be made sitting in the table and discussing their issues. Because this is a traditional settlement is based on our community in South Sudan and in Western Upper Nile. Block 5A has the right for compensation, and we need the world to back us in this. A new way in dealing with businesses should involve community, because now the issue is left with the government to decide on behalf of the community without them knowing what is happening. And this is the case what happened to us. The government of Sudan made an agreement. We didn't know the detail of the agreement. We did not see it. We only saw military guns, military tanks, and people killing us. We didn't know for quite a while why this is happening. It's only later. And we lost so many people on that. Now, this consortium of Lundin were of 3 companies. That is Petronas, Lundin, and NOV of Austria. Petronas was in Sudan until recently. Now they abruptly packed their thing and left South Sudan, leaving behind a trail of environmental violation and impacts. And they left at a time when already an audit was commissioned, environmental audit was commissioned, and the result was about to come out. I must say they must have detected that the result is not good, and they have left. That's also need to be followed up. Why and how do we get into them? Yes, I think those are the main points that I would like to share, and maybe with follow-up question I will be able also to move forward. Thank you.
Thank you so much, Reverend James, for that. And just as we move through and hear from each of our panelists, I think you explained some very important things. The first thing is that, of course, when we think about remedy, it really is not remedy as we think of it. It is remedy from the perspective of the people who are impacted. So you've explained again from your community's perspective what is traditionally remedy. And so that's important. And it includes not only compensation, but as you mentioned, an acknowledgement of the harm. And that, if we think about Pillar 3 of the guiding principles, remedy is a bouquet of remedies, that there are many things. And so again, acknowledgement of harm, apologies, compensation, all of these things are included in that mix. The second, though, is that, as you've mentioned, Reverend James, there is finally, after many decades, a criminal proceeding going on in Sweden, which is being brought against 2 of the former executives of Lundin Petroleum. But a criminal proceeding is not the same thing as a sort of a proceeding that would provide remedy for an impacted community. It is a proceeding that is in the control of the state, and it is still an accountability mechanism, but the question of whether remedy will flow from that many decades later. We have an unpaid debt If you had an unpaid debt, think about how quickly you would be expected to pay it as an individual, but think about how long it's been. And as we now turn to our second speaker, the other issue we're looking at is the issue of remedy. If we have this ongoing proceeding, we have an unpaid debt, how do we deal with remedy in this case? And so there have been other avenues, including an OECD National Compact Point case that has been brought in an attempt to try to deal with these issues and this unpaid debt. So our second speaker can speak about, again, how we've moved from the harm that was caused many decades ago into this issue now of the guiding principles and Pillar 3, which talk about this issue of access to remedy, are there precisely because it takes so long for courts to actually deal with these issues. We are here because of the fact that criminal prosecution and civil litigation have traditionally not been a way to seek remedy. So the guiding principles, we're trying to say there should be another path, and that path shouldn't be dependent on judicial outcomes. But yet we seem to be stuck in a place where that's what we're still waiting for. So we now will hear from Egbert Westerlink from Pax for Peace, who can speak again about sort of where are we now and set the stage in terms of the proceedings. So Egbert.
Yes, thank you very much. First, a very quick update about the trial. The trial started in September last year, and it will continue until February 2026. And the court is listening to 27. The first one was Reverend. Go until on the 11th of September, one of the first suspect, Ian Lundin, will be heard until the end of the year. The past 6 months, the plaintiffs basically all told the same story, fully in support of the indictment. Their contribution to their testimony's contribution to the indictment is basically to provide evidence that there have been systematic indiscriminate attacks on civilians between 1999 and 2003 in Lundin's concession area. That there were forced displacements, abduction, read enslavement, plunder, and systematic destruction, an essential means for survival. And all of them testified unisono, very personal experiences that this has indeed happened to them. So in that sense, the plaintiffs has been very strongly supporting the indictment. The defense has focused on small inconsistencies with the plaintiffs, police interviews, and said in court. But it was all pitchy. It was about dates, places, etc. I personally, I haven't been in court. I've listened to people who report from it, but their impression was that that was all pretty random. There was merely a general effort to undermine the credibility of the plaintiffs, but there was no purposeful attempt to refute specific components of the indictment. The plaintiffs' testimonies did bring out new element in defense of the prosecution's position, which is that there were several of Lundin's former staff members, South Sudanese staff members, who testified that Lundin's staff had been paying militias in Lundin's own compound, fueling militias, cars, providing all kinds of services, which is a very strong denial of one of Lundin's main positions, which is that their operations had nothing to do with the war, with any of the warring parties. Okay, that was the update from the trial. Now the question: will the victims have access to remedy? In terms of recognition, being heard in court, yes. In terms of compensation, reparation, I'm afraid not at all. And this is largely due to, I would say, a very purposeful and successful strategy of the company. The question on the table here is, do the UN Guiding Principles support that legal procedures put an end to the expectation that companies conduct human rights due diligence. I would say they don't, and the main reason for that is that then the right to remedy, that Pillar 3 is basically at stake, as is very clearly the case in the Lundin case, where we see that the Lundin endorsed the UN Guiding Principles of 2012, and in that same year, an investor's proposal to conduct due diligence and to assess its human rights impacts of its past operations was thrown out by a vast majority of its investors, of its shareholders. And the reasons, the reason why the Lundin board of directors advised against that proposal to conduct due diligence was that the private investigation would interfere with the criminal investigation, would be too complicated, and that the issue could and should only be resolved through, I quote, through an impartial judicial process. In other words, they basically said we got nothing to do with human rights because we got a criminal case going on. And very clearly, and I think it's deliberately, of course, they do not mention the victims and their right to remedy, because that's the key thing. They never mention victims. They don't. I mean, Reverend James quite rightly talking about relationships. They as victims with the company, and in that relationship things must be made good. While this company believes it has no relationship with the victims, it doesn't even recognize that there are any. And they are very actively supported by that by their enablers, lawyers and accountants, who have conducted delay tactics. I think the trial would have started years before it actually started, were it not for the lawyers to submit legally appeals without legal merit, to ask for information, and wait to postpone and delay the proceedings as much as possible. A legal strategy that ignores human rights obligations of the company, of duties, and that has been supported by the vast majority of investors. There have been several investor proposals for other human rights sensitive legal strategies that were voted down by a vast majority of the shareholders. The last effort, and one of the most dramatic ones, was of course the proposal, or the appeal by the defense to separate the civil claims of the plaintiffs from the criminal proceedings. The prosecutor warned that that would effectively mean that there would be no access to reparation, and nevertheless the court, the court accepted I would say the blackmail by the defense that they would appeal if it was not allowed, and that would lead then to at least a year more delay. So basically they traded the right to reparation away for another year of delay. I believe that the UNGPs do not support that criminal proceedings put an end to due diligence requirements. But how to convince them, I don't know.
Thank you, Edgar, for that. Yes, this is the discussion that we're having, right? Which is, what is this relationship between the company's commitments to the guiding principles in human rights and this issue of access to remedy under legal proceedings? And again, the reason we have the guiding principles is because remedy wasn't happening. It was delayed when we just relied on the court system. So we're trying to figure out, again, how should we deal with this? How should courts deal with this? And how should companies deal with this as we move forward? So to help us with this and to take through this is Dr. Tara Van Ho from the University of Essex, who has been working on this case and has been working as an expert on this case to help us think through what is the right to an effective remedy, and what does it mean to say that they do respect human rights and have signed up to abide by the guidelines. So Tara, thank you.
Thank you, Anita, and thank you, Reverend James, and for allowing me to be a part of the panel, and for never letting this case go too far from the public discussion, at least here at the UN Forum. Okay. So I'm going to start first by answering Egbert's question: does a criminal investigation excuse the right or the responsibility to do due diligence for the right to a remedy? Obviously, the answer is no. And the answer is no for a very simple reason. That's one component of the right to a remedy. It is not the totality of a right to a remedy. And so today, what I want to talk about is what does the right to a remedy mean? How did Lundin and Acker persuade themselves? I don't think it was a very hard persuasion of themselves that they didn't need to work.
Explain who Aker is in terms
Oh,
of-
sorry. Yes, we haven't actually used Acker's name before. So Acker is the Norwegian company that purchased the majority of Lundin's assets, depriving the victims of having any access to compensation in the case. What Lundin now owns is enough proceeds to pay the Swedish prosecution for the criminal fines. It hasn't reserved any money in its coffers to pay the victims should the prosecution be successful. And for those of you who don't know, when you have a criminal fine as your remedy, if you have a criminal fine, that money goes to the treasury of the state that did the prosecution. It doesn't go to the victims unless there's a separate legislative process, and my understanding is in Sweden. Now, please forgive me, I'm not an expert on Swedish law, so I am relying on what the Swedish lawyers tell me. They don't have that as a system. So you can attach, as happened in this case initially, you can attach civil claims to a criminal prosecution, but the remedy is a separate part. So you can have an obligation to provide a criminal fine or to pay a criminal fine, and then separate to that is the victim's compensation. So the victims will not be entitled to the criminal fine that Lundin may be required to pay. So let's talk about remedy. It's in the International Bill of Human Rights. I say that because what does the UN Guiding Principles tell us to do due diligence on as a minimum standard? The International Bill of Human Rights. You're supposed to start with the Universal Declaration, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. 2 out of the 3 of those explicitly recognize the right to a remedy. The Covenant on Economic, Social, and Cultural Rights does not, but the other 2 do. And when we're talking about what we're talking about in this case, war crimes, extrajudicial killings, displacement, and the destruction of property, you're talking about violations of the Universal Declaration of Human Rights and the ICCPR. The right to remedy is an individual and autonomous right. It's also a subsidiary right that attaches to every single other human right. So it is important that we recognize what we're talking about is deprivation of multiple rights to remedy here. Both the individual right to remedy as well as the right to remedy that attaches to the right to life, the right to freedom from torture. The right to remedy isn't just recognized as a matter of the International Bill of Human Rights, but it's also a long-standing right within customary international law. There has always been a recognition that a right is only as strong and a legal obligation is only as strong as it is enforceable. If you cannot actually claim your right, if you cannot enforce your right, then what you have is a really nice hope, wish, and dream, but not a legal obligation. And so customary international law has long recognized that every human right, every international legal obligation carries with it this obligation to remediate when there is a violation. So if a remedy is a human right, why wouldn't it be part of human rights due diligence in a merger and acquisition like what you have with Aker and Lundin? Why wouldn't it have been part of Lundin's long-standing responsibility, regardless of the criminal prosecution? The reality is what the companies are hoping is that in a merger and the merger and acquisition of Lundin's assets fundamentally excuses and confuses people, that we just forget about it and move on, that the complexity of trying to go after the assets just becomes too burdensome for the victims. It's a common and increasingly common choice by companies. So we are seeing this in places like Nigeria, where a very large and well-known oil company, who I shall not name, is divesting from all of its assets and hoping that, somebody else will figure out how to remediate the victims in the Ogoni region and in the Niger Delta, just to give you a little hint as to which that company was. You're also seeing it in places like Ukraine, where businesses have a responsibility attached to violations that are occurring within the course of the conflict, and in Palestine, where there are long-standing obligations on businesses that were associated with the illegal settlements. And in these conflict affected areas, what you're seeing is a willingness to leave the situation or a willingness to, skirt around who has responsibility, maybe sell off some of your property, maybe have a subsidiary, maybe have a franchise, all in the hopes that it becomes a little too complicated to go after the remedies so that the victims eventually give up. And we've seen it be a successful strategy. Esther Kiobel fought for 30 years to get justice for her husband and the other Ogoni leaders. And then she had to give up because at some point the burden on her became too great. We've seen it in other cases as well. So that's what they're hoping to do. But what Sweden, what Norway, what the OECD National Contact Point, and what the rest of us have a responsibility to do is insist on remedies as a part of their human rights due diligence. So what would that mean? First, it would require understanding both the process and substance that were available to Reverend James and his colleagues. It should be done in consultation with the victims, as with all other due diligence processes. You should be understanding what does it mean for victims to access the right to remedy in this case, procedurally and then substantively. We have already heard from Reverend James what they would have asked for. They would have asked for an acknowledgement of wrongdoing. By the way, in international legal terminology, we call that satisfaction. It is one of the primary pillars of the right to remedy from a substantive perspective. And they would have asked for compensation appropriate to their losses. I'm glad that the Sudanese government now has a program in place to have 3% of oil proceeds allocated for damages. But that's not always sufficient. And there needs to be an acknowledgement by those who have committed the wrongdoing, not just by any of us. And there needs to be an allocation of resources from those who have caused the harm. And particularly when we're talking about businesses, particularly when we're talking about transnational corporations, that contribution to the compensation isn't just about the financial burden that the victims have had to bear. It is also a part of that acknowledgement of wrongdoing. There's a link there that we shouldn't lose. There are also demands for criminal prosecutions as a matter of international law, where you have had a criminal violation of human rights. There is supposed to be an effective investigation, prosecution, and where appropriate, punishment. So Sweden is providing that part of the remedies, but that's one component of what's owed. You also should have, as a matter of international law, rehabilitation. So that can be physical, mental, social, economic, your ability to have rehabilitation for jobs purposes. There should be restitution, meaning a cleanup of the activity or returning of property that was destroyed or looted. And then finally, there need to be guarantees of non-recurrence. Now, I have long believed that one of the most effective guarantees of non-recurrence would actually be to close up the operations of a company. That doesn't mean a voluntary closing up by merger and acquisition. It doesn't mean selling off your property so that those who were part of the problem in the first place financially benefit from the violation while the victims don't. It means that when you're talking about a guarantee of non-recurrence, you should be looking systemically at what changes are necessary to the operations of the corporation to ensure that this doesn't happen again. Not just to the victims in this case, but to victims across the world through your operations. That requires showing that you actually understand due diligence and that you take it seriously. When you're refusing to do it in this case, when you are purchasing a property and assets without doing your human rights due diligence, how can that ever be an effective guarantee of non-recurrence? And how can we ever have confidence in you as a company that you would engage in effective guarantee of non-recurrence? I would also posit that in this case, it shouldn't have just been normal human rights due diligence, but actually heightened human rights due diligence, both because this occurred in the context of a conflict, but also because South Sudan is in the midst of a conflict and is always at a risk right now of recidivism to conflict. When we talk about human rights due diligence or heightened human rights due diligence in conflict-affected areas, it is not just about the tiny moments of conflict, but it's about what leads to that conflict to begin with and what happens after the conflict. And we know, because the social sciences tell us, that for 14 years after a conflict, a state is at a heightened risk of recidivism to conflict. You need to be applying that heightened human rights due diligence in a conflict-sensitive way that helps you understand what are you doing to the population on the ground? What triggers to conflict are you exacerbating or hopefully alleviating? How do your relationships with the government, how do your relationships with the population on the ground increase or decrease the likelihood of conflict arising? And when you are ignoring the demands of the victims, when you are treating their losses as something to do on your balance sheet or something to resist in your human rights due diligence processes, what you are doing is impacting on the dynamics of the conflict. And so there's a serious denial of that by both Aker and Lundin. By the way, it is a joint responsibility of both parties. It is a joint responsibility of both the seller and the buyer in a situation of mergers and acquisitions. And it's a problem that neither of these businesses took that seriously, but neither did either of their home states. Aker is now at a national contact point for the OECD, and it has claimed that it had no need to do due diligence because there is no right to a remedy outside of a treaty protection. I mean, if that's true, then I don't really understand what the purpose of an NCP is. Because the NCP is a non-judicial grievance mechanism that sits in place of or fills a gap where regional treaty bodies or other treaty bodies don't exist or can't provide an adequate remedy. The guiding principles and the OECD guidelines would both lose any meaning if all that you're talking about is state-based treaty mechanisms. They've also said that Sweden provides an adequate right to a remedy. And I would suggest that if that were true, we would not be here in 2024. I would love for it to be true that Sweden provides an adequate right to an effective remedy for the victims from South Sudan. But then why have I been working on this case for however many years? Why has Egbert been working on this case? And why has Right Reverend James had to fight just to be heard in the Swedish courts, not even to have his own claim adjudicated?
Thank you very much, Tara, for really explaining to us what the right to remedy is and how it relates to the guiding principles, and really the question of how can companies take positions that really eviscerate this idea of a right to remedy. I think the challenge for us all is that the criminal proceeding is underway, and the company's position, both companies, both Aker and Lundin, is while it's going on, will they provide any kind of settlement or anything? And the answer, of course, is no. Right? They're waiting for this process to wind its way through. And in the meanwhile, we're seeing what Tara spoke about, which is the disappearing corporation, right? While we're waiting and waiting and waiting, there is no company left to provide the remedy. And that's through mergers and acquisitions or other kinds of mechanisms that corporate law permits. So our last speaker is going to speak about, again, other attempts to use leverage to address this issue, which is the role of investors. Again, we've spoken a lot at the UN Forum on Business and Human Rights about this idea of leverage. Have investors been instrumental here? And so to hear about this, we have from Swedwatch, Olaf Bjornsson. And so Olaf, please tell us, can investors make a difference here?
Let's see. Yeah, for those of you who don't know, Swedwatch is a Stockholm-based NGO, and we've been doing research and advocacy on the Lundin case since 2017. We're one of the complainants in the NCP complaint, currently before the contact point in Norway. But our work has mainly focused on the responsibilities of those Swedish institutional investors who were invested in this company from the very start. These are the big Swedish banks and government pension funds. And we've been doing research on this and different types of dialogue to see how they have acted on these allegations against the company that they are invested in. And it started with this report that Swedwatch published together with Fair Finance Guide in 2017, where we set out to find out how an investor acts when confronted with these types of allegations. And I think the findings illustrate quite well the different things that we've discussed here today. And for a bit of background, so pretty much every major institutional investor in Sweden have been invested in this company at some point, either during the events in Sudan or shortly thereafter. So what did we find? We found two things basically relevant to this discussion. And the first thing is that, I mean, the extent to which these investors tend to mix up their own responsibilities with the kind of with the criminal investigation and the upcoming trial. I mean, just the fact that there was a criminal investigation going on pretty much paralyzed these companies not only to act, but even to try and find out what really happened. And unfortunately, this way of thinking is very much still alive, I think, in the finance sector. Only last year, one of my colleagues talked to a major pension fund provider in Sweden about the Lundin case, and one of the analysts stood up and said, well, you can't know if there are any impacts that need to be remedied because the trial is not over yet. So this, to me, this kind of closes the circle and puts us back at the point before the UNGPs even came into effect. And the second point is about information. I mean, maybe considering the severity of these accusations, a lot of these investors and shareholders have said that we can't know what really happened. There's no way of knowing what took place, and it's a case of word against word, as they say, when in fact there is abundant information about what happened in the oil areas of Sudan during the war. And also, I mean, lack of information is a strange position by the company who is responsible to conduct the human rights due diligence and find out what really happened. But there's another aspect that if you read the report, it's pretty clear that as more and more information came out regarding what had happened and the crimes that were committed in the oil areas, the more these investors bought shares in the company. So information about these atrocities did not deter investors, on the contrary. And I think this brings us to the question of what is sufficient information for a shareholder to act. And in the case of Lundin, I mean, there have been shareholder proposals to investigate and start independent investigations to look into what really happened. And most of the investors we talked to either did not vote or actually voted no to these proposals. So it's kind of a double standard where you say that there's not enough information, but at the same time, you're kind of stopping the different initiatives that would find out what happened. And yeah, the culmination of this is, of course, what Tara mentioned, where the remaining shareholders just voted to cut up the company and move all the assets to Norway, out of reach of the victims. And yeah, just to clarify, these are big institutional investors. These are not SMEs that don't have the capacity to conduct human rights due diligence. I think so. This has to be due to a lack of will. And I think the conclusion is that human rights, especially maybe the right to remedy in these types of cases, is not really addressed by institutional investors in the way that they should be. And yeah, of course, this is also reflected in the CSDDD, the Corporate Sustainability Due Diligence Directive, that totally exempts the financial sector from these responsibilities as well. And I think that's sad, because the financial sector potentially has an important role to play here. And yeah, it's important for us in civil society in the coming years now, to keep up the pressure and make a change here. Thank you.
Thank you so much. And Reverend James, I see you've been writing some notes. Would you like to maybe share some additional comments as we open the floor for questions?
Well, is the issue of avoiding talking to the victims. The report of unpaid debts was launched in 2010. And since then, we contacted Lundin in order to have compensation with them. But they deny that. They blocked and they said we have done nothing. Wait for the court. Now we are in the court. And the court, as explained by Egbert, part of what we have claimed, which is the right to compensation, was denied and was traded for us to get the court take place, which to us is a step forward, but still we need to come back to this, because without this, then the whole thing will not deter anybody, especially those with the money. They can do anything, and at the end they will pay it. They'll pay the government, they'll pay the fee, the lawyers, and whatever it needs, and it will go like that. So I think we need to think outside the box.
Thank you, and that's part of. In addition to your questions, I think as we're seeing this challenge that we're here with a proceeding, and we're in a world of what good are the guiding principles if we're in a world where, again, it's about waiting and waiting and waiting and delaying. That's the world we were in that led us to this place of the guiding principles. So your idea is, how do we move forward and actually think about remedy and accountability today for the Lundin case, but for other cases, knowing what you've heard from Tara and others. So with that, the floor is open for your comments and your questions, and for those online as well, please do join in. So I see Tricia in the back, and if someone could provide our colleagues with a microphone.
Hello, good afternoon. Thank you everybody for being here today and for such an interesting panel. I'll keep this very brief. I was curious, the gentleman, Olaf from Swedwatch, if you've had any traction with investors around ESG. So if we don't talk about human rights, but we say that this is going to have, this is a social impact, and certainly it feels like, at least in the US for a bit, a short minute, there was a bit more traction with ESG, and I'm just curious what your conversations have been like. Thank you.
That's interesting, and maybe Olaf, you could add to that the CSRD, right? Are these issues going to be so material that will that disclosure make a difference? So one question, but let's have some more as well.
Hi there, Suzanne Spears from Paxis. I was just wondering, Tara or someone else, can you clarify what happened with the civil remedy in the Swedish courts? It got disassociated from I remember this happened last year during the forum, and I'm sorry, I haven't followed up on what exactly happened, and can it be revitalized?
Thanks, Suzanne. Let's take at least one more. Is there anyone in the room or online? There's two more, so this is great.
Hi, Stephanie Borovich from CORE. I was wondering if there are any sort of good practice examples you could mention where this has, where the rights holders were involved in a more sufficient way, or where the state has more sufficient practices in that case. Thank you.
Thank you. And Jenna in the front.
And actually, just to follow up on that, has there been any talk of sort of preemptively companies putting in money for funds, right? So in case something does happen, the money is already there and able to be accessed.
Thank you for that. And I think we'll hear that there is money on deposit, but it's not for the victims. But that larger question of, right, are there examples where money has been put in some kind of trust for a remedy? So with that, why don't we begin again? I'll begin with you, and then we'll go to our other panelists on ESG or other kinds of.
Regarding ESG, I think the crux of this case is 20 years old. And I mean, to a former employee of ESG rating agencies who said that, after 1 year, a case is considered historic. And so, but I mean, in our opinion, none of these impacts have been remedied. and so to a large extent, I mean, the trial is ongoing. They're opening a new case now on witness tampering, because many of the witnesses say that during the proceedings in court, they say that they have been threatened. So this is, like, from my perspective, being a non-lawyer, this is still very much ongoing. But I think from the ESG perspective, kind of bringing up 20-year-old cases is, not really.
So in the civil case or others, Egbert?
Yeah, about ESG, Lundin got a very high ESG rating in 2019, and I asked for the raters, what's your logic? Well, basically, you can offset a poor rating in one part of the system with a high rating on another one. Well, they produced oil in the Norwegian continental shelf without any CO2, any contribution themselves. Yeah, so it's climate neutral oil production, which gave them so many points that this controversy, was completely outwiped, and they got massive, very high, very successful ESG ratings. So much for ESG.
Tara?
Yeah, sorry, fossil-free oil production was their slogan. Yeah, and also just one more thing. When we did the research for this report, they were actually put in some kind of sustainability funds by these institutional investors. So
Tricia, great question, right? Although unfortunately not the right answer. Tara.
Yeah, I can do that. Yeah, sorry, about the civil and criminal claims. Yes, in November 2023, so just after the start of the hearings, the lawyers of the defense said that the 32 civil claims of the 32 plaintiffs that had been submitted 2 weeks before the start of the hearing should not be included in the criminal case. The reasons they gave was that the criminal case was based on a structural pattern of war crimes and did not in detail describe individual crimes, while the civil claims were all based on very specific criminal events. So they said basically this means that we have 32 lists of new legal facts that will have to be studied by us, each of them individually, etc., and we will not be able to do that because we have a tight schedule in these 2.5 years anyway. It's pretty ridiculous. I mean, there are 7 or 8 lawyers in court. They have 8 million legal budget every year paid for by the company. So, and I don't have months and months of free time. So, but anyway, they basically threatened the court that this would lead to 1 year delay. And the court swallowed that. And the consequence now is that each and every of these 32 plaintiffs will have to start a separate civil lawsuit against the company. The company also, their lawyers requested that each of them would deposit 45,000 euros in collateral in case, because they were not Swedish, in case they would lose, they needed guarantees that the legal bills of the company would be settled. So much for the right to remedy. I mean, it's quite understandably the prosecutor was furious.
So Tara, some of the broader questions about other examples, good practice.
Yeah. So good practice examples are always a little bit difficult to come by when the people that you work with are the NGOs who are representing the victims of the companies that do bad, right? So like things only really come to me because someone has messed up so severely that now we're looking at a transnational corporate claim. That said, there are a lot of examples where it doesn't get to that level because companies engage early. I am admittedly having a really hard time coming up with some of them. And partially because the ones that I can give, I've signed confidentiality agreements with the companies to get access to conversations on those things. I will say that there is an example of a few examples of groups that have set up good remedial practices. Amphori, has a remedial process in Southeast Asia that looks good. That's one where I haven't signed a disclosure or an agreement not to discuss it, and that seems to be a quite robust, I'm only looking on the outside, it seems to be a quite robust procedure. I think that would look like a very good example of non-state, non-judicial grievance mechanisms and remedial processes for other businesses to follow. Unfortunately, when it comes to doing due diligence on remedy and access to remedy in situations like this, I don't know of a single good example at all. And everything that I do know is a really bad example. It's examples of Chevron fighting the Ecuadorian government and victims in multiple jurisdictions and saying, yes, we'll abide by the Ecuadorian courts until we don't like their decision, and then we're going to fight them using international investment law. It's Shell and Esther Kiobel. Those are the cases that unfortunately I think are more the norm than good practice.
I'll just actually jump in to say that the only example I can think of, which is one where political influence made all of the difference, was that in the 1990s, as we were dealing with all of the cases against Shell and oil and gas companies or extractives, were cases that were focusing on litigating claims related to the Holocaust. And so cases against European companies, insurance companies, banks, and dealing with unpaid claims of forced labor and other kinds of issues, where actually there were lawsuits brought for very historical claims. And thanks to government interference or influence, you had settlements, you had companies paying into funds, you had actual claims adjudication and commissions and other kinds of things. So many people who are in the human rights community haven't focused on those, but I would just say that that's the one example where if there is a will, there is a way. And so just to say that it can be done.
Can I just jump in on that to say, yes, I think that is the best example. I think the political pressure, though, how significant that political pressure was, is really telling, right? Because you had the European companies take responsibility at the same time that the Japanese companies did not. So you had the Mitsubishis and others fighting those claims and denying compensation to victims. And it was the political pressure by the states, I think, that made a huge difference. Also, the fact that 50 years had gone by and everyone acknowledges that the Holocaust shouldn't have happened. There's no real disputing over the underlying facts or responsibility there, right? It's amongst some, I would say it is the most documented criminal violation of human rights that we have in history. So you had a little less wiggle room in terms of saying he said, she said on this issue.
But again, so Reverend James, back to you.
Yeah, though the case have taken long, to us is new, as long as it is not settled, because we lived it every day, and the memory is still there. So it's not old to us, as long as it's not settled.
So I see we have time for an additional round of questions. Chloe?
Hi there, I'm Chloe from Anti-Slavery International. Just going to say a comment. You can read between the lines, but we're talking about the Holocaust. I would just flag that Volkswagen continues to operate in the Xinjiang Uyghur Autonomous Region. And then linked to that, so yeah, we work really heavily on the Uyghur region. I think one of our Uyghur partner groups might be here as well. And one of the questions we thought about when speaking about the Uyghur region and right to remedy is actually there's no access to the region. The only way you can access the region is essentially if you're operating some kind of greenwashing exercise, and otherwise you'd be putting yourself at severe security risk. So I'd be interested, particularly probably to hear Anita and Tara's opinions on how can we even consider access to remedy in this ongoing abuse. So Uyghur forced labor has been concluded by UN human rights experts to likely constitute a crime against humanity. So in that context, particularly when we continue to have international buyers and companies sourcing or even operating in the country, what does right to remedy look like where there is no access and where the survivors themselves are basically having to live hidden lives elsewhere due to also the risk to themselves when they're not even in the country? Thank you.
there was a hand in the back of the room. 2 or 3.
Anna from Sherpa. Thank you so much for the presentation today. I have a question regarding access to remedy for the victims. As you mentioned, it's been separated, the civil claims, and they would have to file separate claims and allocate 45,000 for compensating the company if the claim fails. Has there been a collective voice of the victims in terms of maybe if on the judicial criminal side it doesn't work to access remedy, to maybe pressure the investors in the new company by, name and shame and highlighting the injustice of merger and acquisition, making it impossible for victims to access remedy through the judicial system. Thank you.
Thank you.
Hi there, Roy from Amnesty International. Thanks for this incredibly powerful panel. Really appreciate the distinction between the difference between the principles that we have on paper and the way it looks in practice. I had a question for Reverend James, and it goes to the point that you made about what sort of remedy you and your community would be looking for. And you mentioned that it was quite powerful to be sitting in that same room with the 2 defendants from Lundin. And I'm curious, if they don't ultimately agree to provide some sort of acknowledgement to the harm that they've caused to you and your community, is it significant to you and your community that that they be made to pay some sort of price in terms of a criminal sanction? At the end of the day, this is a criminal case, and they are accountable and may have to face criminal consequences for their actions. Is it significant to you and your community whether they're ultimately convicted, whether they have to pay a price in terms of going to prison or losing their liberty? Is it significant to you whether that price is then deters other companies who may be wanting to do, or other executives who may be engaged in similar activity around the world? I'm curious for your views on that. Thanks.
Great. And I think there was one additional question.
Thanks. Peter Irwin with the Uyghur Human Rights Project. Just a general question on the CSDDD. I think Olaf had mentioned it, but I wonder if there's general views on, perhaps not in this case, but elsewhere, opportunities with CSDDD. It's in the remediation element of that. It's quite early days, but maybe going forward, just general comments on that.
Thank you. So just to recap, we have several different questions. One is around access to remedy in a situation where there are ongoing harms, but you can't even access the place to address or investigate the harms. The second one is on, again, if we think about the company that acquired many assets from Lundin, what about sort of collective action or naming and shaming or addressing that through investors in that place? The third, Reverend James, in terms of you and the other community members, when you think of remedy, what does the criminal proceeding mean to you in terms of thinking about remedy and having the executives held accountable? And then the CSDDD and sort of remedy now, and what does that change anything? So with that, Reverend James, maybe we begin again with you and your thoughts on the criminal conviction. What would that mean?
Well, as you know, this case have taken 20 years. And it was like lost already. The fact that is now on surface and people are talking about it, and we are in this room, and one of the topics is Lundin, I think that alone is signaling that no matter where you hide, you will surface. Because what they did is terminate their contract in South Sudan, run to Sweden or Geneva, hide, and blocked us, no contact, no nothing. They thought that is, they are under blanket and they will not be reached. So now the fact has turned, we have reached them, they have appeared in the court, they were in the newspaper that convicted. I think that's enough signal. It's not going to pay our debts. It's not going to pay us anything in tangible thing that we could be proud of. But the fact that they are in the news and everybody has known, now other company will take that as a lesson. And since they are still in the court, and they were able even to move further, acknowledging that they have mistaken, move their assets to another company, just taking precaution to hide, and we are still following them from there. I think this kind of hide and seek is going to be a deterrent also to other companies. So yes, it will be a great loss that they will not compensate. But the fact that we are following them, and this case is not going to die. I know we have already lost so many powerful victims. Those were witnesses waiting for this case. During these 20 years, they have gone. The last one was a paramount chief of our area called Tungwar, which is 100 and something. We just lost him last year. He was waiting for this case. But good enough, his son is also a victim. He's in the case. So those painful events, yes, we have been carrying them for the last 20 years. We'll wait for another few years to come. But hopefully this is going to be uncovered. Yes.
Tara?
Okay, so Chloe, the question as to what does remedy look like in a situation where there are ongoing violations and you can't access the region? There is no remedy in a situation like that. What does a remedy require? A remedy is the consequence of unlawful conduct. So you stop the conduct. You cannot be providing remedies. And this, by the way, again, when we talk about other situations, you have Danish companies that are currently supplying the Russian military with equipment and then saying, oh, but we gave humanitarian assistance money to Ukraine. That's not a remedy. A remedy requires an acknowledgement of wrongdoing and is the consequence of your wrongdoing, which means that you need to stop the wrongdoing. And then you can start the process of remediation. Additionally, within that context, what I would say is that stopping is the first guarantee of non-recurrence. So if you want to show that you are serious about remediation as a company, and I'm not going to name the companies, but I do have an academic article out there that names several of them. They owe a responsibility to stop working in the region. And if you can't access, if you cannot provide due diligence in a region like Xinjiang, and you can't, Chloe is right, it is impossible to do human rights due diligence in that region. You cannot operate there in compliance with the guiding principles. You need to leave. And the fact that those companies are still there, it's beyond shameful. Anna, how do we pressure new investors and use collective action? The reason that a one-year case is considered historic by institutional investors is because generally speaking, the share price from naming and shaming will have already bounced back. So any negative impact that you get from naming and shaming within 1 year will be wiped out. And that's because institutional investors don't do their own human rights due diligence, and they don't care enough to do their own human rights due diligence. They still fail consistently. And by the way, I have tremendous respect for people at many institutional, many is too many monies. I have tremendous respect for people at a couple of institutional investors. And yet, I don't think that they themselves do their full human rights due diligence yet. Until we start capturing, and this goes back to Olaf's position on the CSDDD and the exclusion of the financial sector, until we start capturing them, they're never going to do the human rights due diligence, which means that the companies don't have the long-term consequences that are necessary to dissuade them from engaging this wrongful conduct in the first place. By excluding the financial sector, all 27 member states of the European Union have failed in the basic expectations of states in their duty to protect. So let's be clear, we're going to talk a lot, we can talk a lot about the businesses, but we have 27 member states that are out there celebrating how great and wonderful they are, how much they have saved humanity with the CSDDD, and they failed to meet the basics of their obligations. So how much will the CSDDD lead to remediation? First, it needs to be instituted by those same 27 member states that have already failed in the minimum expectations on them. It's also non-retroactive, so obviously it won't provide any support in this case. But I think there is an argument to say that in the future, you will have to do due diligence in a case like this, that under the CSDDD, Aker will have failed to meet its obligations. It's an argument that I'm not going to get into in detail now, because I would like to support whichever NGO takes the first case for the business that fails on that, because I don't believe that any of the businesses are going to be serious about it anyways. I'm sorry, that was extraordinarily pessimistic. I got a little cynical there. I do believe that there will be many businesses that actually do take the CSDDD seriously. But I think that's how much it will make a big difference in the major companies will very much depend on how much the rest of us hold these corporations accountable and work repeatedly to take cases like this forward and seek true accountability, both criminally and civilly.
Right. So we'll go to Bjorn and then Egbert.
Well, if you don't mind, I have a question to you or to Tara. If you all agree that that legal procedures do not put an end to due diligence requirements, then how to understand the answer to question 33 in the frequently asked questions about the guiding principles on business and human rights, and I quote, "Some human rights abuses, such as those that give rise to potential criminal liability and or amount to gross human rights abuses, should be remedied through judicial mechanisms wherever possible. And in other cases, for example, if a court process is underway, it may be appropriate to defer to that process rather than pursue remediation through non-judicial mechanisms." Shouldn't we do something about this sentence then, or?
You want to say something? All right. So the reason I'm going to postulate here, because I did not write that sentence, nor was I involved in the process. But generally speaking, what we want to avoid is businesses on their own in a situation like South Sudan or Colombia, designing a process that is aimed at washing over their criminal responsibility or their complicity in a situation. And so you don't want to embolden businesses to start saying, "We'll give you $5,000 US, and isn't that so much money?" Just don't push forward on the criminal side of things. Don't engage the the NDAs, the non-disclosure agreements. And so I think that's the origin of that, is that we have seen that kind of a process. I do think perhaps that sentence, in light of your question, a sentence that I had not thought about in a very long time, I think there could be a little bit of more nuance on that. And I think also what you're talking about there is sort of, sorry, I need a second to formulate. You threw me for a loop there. I think there is something to be said here around the difference between what are your responsibilities to remediate and what does that process look like and how do you follow through on that, versus what are your ongoing responsibilities in terms of due diligence around the right to remediation. And so I think there are times in which you do wait on the judicial process, but that also shouldn't be an excuse to use the judicial process to delay the remediation, right? So it's, if there's an effective remediation, it's supposed to, adequate and effective remediation as a matter of international law is supposed to be expedient, right? It's supposed to be accessible, but also quick in terms of its accessibility.
And I could just chime in. And again, I think you did threw us both for a loop. This is like, professors are meant to throw their students, but you just threw us. It doesn't say always, right? It says that sometimes. So if there's a civil proceeding going on where remedy may be forthcoming, then there may be a reason to toll other kinds of proceedings, right? Whereas here, what you've already told us is there's a criminal proceeding underway, but the civil claims as a result have just been washed away. So I think, again, it's not about, in all cases, because there's an illegal proceeding, you forestall other things. I think that's the issue. Just two other quick things, and Chloe, to your point, again, I think the larger issue is that Tara's point is right, which is that you know, again, the first point is you stop. But there are mechanisms to try to get companies to stop, right? That there are the tariff acts and other kinds of import bans which put the burden on companies, and if they can't show anything else, they've got to stop. But stopping isn't the full point of remediation, right? So that's the beginning, as Tara said, and I think that's the larger challenge for us, which is when we talk about rights holders, what obligations do companies have for the fact that they were operating in certain places for that harm, and how do you reach a rights holder? I don't have that answer for you right now. That's the other piece. So I think the stopping we can potentially address, but the next piece is the other. And then so here we are with respect to all of those. But Bjorn, why don't we hear from you, and then back to Reverend James for the last reflections on these discussions.
Yeah, I mean, regarding remedy for crimes like these, according to the CSDDD, I mean, I don't know. I'm not an expert on the CSDDD, and I don't think anyone knows. It's early days, like you say. And I think, I mean, it depends, like you say, on the transposition. I mean, the CSDDD is a minimum level in some way, and we'll have to wait maybe until 2030 when it's reviewed to see whether it's been working in the way it's intended or not.
There's an avenue for lots of litigation to begin. So I think, again, and just one other thing to Tara's point, which is just that when we talk about human rights due diligence, and Tara and I were both experts in the NCP case against Aker, and I dealt with the mergers and acquisitions. Companies that are acquiring the assets can do due diligence, and they can ask for funds to be put aside, to Jenna's point, for a remedy, right? That there could have been many steps taken to provide remedy, or to make sure remedy, once the case is done, is there. And that's the missing piece, right? Is that due diligence component and sort of remedy assurance as part of due diligence didn't happen. So Reverend James.
Well, the case of South Sudan with Lundin, and probably any other case in the third world countries, is difficult to move from that stage to the international stage unless you have collaborators that are supporting you, and mainly NGOs, think tanks, like our case. If the European coalitions on oil did not come up in our support for us to write the report, that is now the basis for the case, which is unpaid debts, then we will not be here today. And therefore, teaming up with like-minded human rights organizations and bodies is the help for communities that are not reached. Churches also are another avenue that we could use, and the media in general. So our appeal is that we still need that support, even though we have gone to the court now. But the bar is being raised every now and then for us not reached. So we need your help. Thank you.
Please join me in thanking Reverend James. Thank you for coming so far. Our other panels. And I hope, again, for all of us, that we aren't back again next year having that same discussion.